Hey, folks, greetings from the Offensive Security Group here at Secure IT 360, coming at you with a new episode of the Cyber Threat Perspective. You've got myself, Brad, we've got Alex here, and Spencer. So as an introduction to Alex Boyd is a shareholder in Paulsonelli's. Did I get that right?
Yep,
All right, perfect. Their national technology transactions and data privacy practice. And so he's going to be here to talk to us about really giving insights for CTOs, IT directors, CISOs, stuff like that, about responding to security incidents, right? So we're also going to get some insight into breaches, how they work, mistakes made, all that good stuff. So we're really excited to have you here, Alex.
Yeah, thanks. Yeah, looking forward to speaking with you guys.
Fantastic.
Yeah, awesome.
So Spencer, do you want to take it away, man? Yeah.
Paulsonelli's, that's like a 12-point word right there.
Law firms are all about, names and branding and those kind of things. And
Yep.
Fortunately, been around for a while and it's a growing firm and always kind of on the cutting edge. And to where I get to do kind of all sorts of exciting things in the cybersecurity space. So
yeah, awesome. Yeah, so I know we're going to jump right into talking points, but maybe just a quick background filler. Who is Alex Boyd? Where do you come from? What got you interested in this specific field within the legal industry, and kind of what you spend your time on in your days doing?
Yeah, sure. So I'm an attorney at Paulsonelli's, a law firm. It's about 1,000-person law firm, so kind of a large firm here in the U.S., kind of all spread across the country. I'm here in Kansas City. But my practice is really focused on cybersecurity and data privacy. So when I graduated law school, I was a litigator for a while and kind of doing more general practice. Got into kind of the data privacy space, drafting terms of service and privacy policies for websites. Kind of back when the time when you kind of just cut and paste those, and no one necessarily read those too closely. That was kind of before GDPR, and it was not more of just say, hey, check the box, I've got one. But as those regulations came out, kind of realized, all right, there's a lot in the data privacy space. Okay, what actually are you collecting, and who are you giving it to? And so that kind of got me really excited about just the internet and data privacy space. So I was practicing in Omaha at the time, and I was kind of looking. It was a part of my practice, but it was at a smaller firm, it's harder to specialize in that, especially in an area that's moving all the time. And so I was looking for a place where I can kind of specialize in that. Moved down to Paulsonelli about 5.5 years ago now. And we've got a large team here. We really have a chance to kind of dig into those kind of specialized issues, which is kind of what I'm doing all day. So I'd say 80% of my practice is probably responding to data incidents of some kind, and then 20% we kind of leverage all those hundreds and thousands of incidents to help our clients either reduce the risk of an incident, although you can't prevent them all, right? So we do a lot of work to try to prepare to respond to those because it's going to happen at some point. Let's hit the ground running and try to do those kind of things. So nice. That's what I'm doing all day. I've got 2 kids, 6 and 9, at home. That keeps us busy. Tomorrow's the last day of school for them. So
nice.
I'll be off for the summer and having a good time. So it's always fun stuff going on.
Yeah, I'm going to make the joke before Brad does because I've got 11 kids, so I know that life very well.
Yep. Yeah. I'm lucky. I have triplets. They're all grown and graduating from college right now. So easy. I got the easy job.
Yeah. So I want to start off and just ask if you can just talk directly to CTOs, IT directors, CISO, security managers, kind of people in charge of IT/security at organizations, no matter the industry or their vertical, because I'm sure you work across the board. What's the number one piece of advice you would give, or what's the number one thing that all those IT managers, CISOs should know about when responding to a security incident?
Mm-hmm. Yeah. So selfishly, my advice is kind of things that make my life a whole lot easier as the legal counsel and helping these organizations respond. So I think it's just helpful for the security professionals to realize you are a really important role on a very large team, that's responding to an incident, right? So an IT security incident isn't just a security IT issue, right? Depending on what happens, you've got legal issues, communications issues, reputational issues, operational issues, right? And so it's helpful for the people that are really on the ground, kind of frontline, IT professionals to understand. All right, I'm a really key part of this, but there's a whole lot of other stuff going on. And so kind of understanding the bigger picture is really helpful because, what causes a problem sometimes is, when an IT professional kind of they try to become the hero and kind of do everything themselves and try to fix everything all on their own. And that can sometimes backfire and cause worse problems down the road. So it's just, making sure you're coordinating with all the other people and understanding that, hey, this isn't just, someone got into the email account. I guess we'll reset the password and I think we move on now, right? Like nothing else happens. Well, probably not. It's just recognizing that, hey, I should, let somebody else know about this, bring them in, make sure we're all on the same page. We're not stepping on each other's toes. And that's going to help, the organization as a whole. So, the IT department isn't running everything. Obviously, super critical to containment and investigations, all those things. But like understanding that there's potentially a lot of other things that are going on or that should go on when you respond to those incidents. So it's kind of just taking that bigger picture when you're looking at it.
Yeah, our frustration point, shared with you a little bit, and not even so much from a consultancy perspective, but even when I was working, in the corporate world, is we pay all these people all this money, and they have all this expertise, and everybody's at the table during an incident, but we don't want to let them work. We don't want to let them do their job because we on the ground as the corporate guys kind of think that we're, like you said, we're supposed to be the heroes. It's our job, but we need to let you guys work within your area of expertise because it's in our best interest. It's the reason we hired you in the first place, right?
Yeah. So if you could just expand on, like, what's the role for counsel in preparing for and responding to these incidents, right? Maybe if you can give some examples or just put some tangible information around, like, what is the role of counsel and how can IT people, security people, how can we kind of let go of the reins a little bit and kind of let you guys help and let you do your job to help, ultimately the organization be more successful at whatever it is they're up against?
Yeah. So I think we kind of take a layered approach as you kind of do in IT security, right? So ideally we'd reduce the risk of all security incidents, but you can't prevent all the incidents. So kind of step two is, all right, if we can't prevent the incident, let's reduce the scope of it. Right. So if it's instead of involving everything, it involves a subset of data, whatever that might be. So that's kind of number two. And then the third one is, all right, you can't prevent them all. You're going to have them at some level. Let's prepare to respond as effectively as we can. Right. And so there's kind of a role for counsel in each of those. So kind of in the first one of kind of reducing the risk of an incident, you have to have those risk assessments. You have to have the penetration tests to really kind of figure out, okay, what is the risk, and then addressing that. And so that's primarily an IT function, right? I'm not the one going in there and I'm not looking at logs and CVEs and all those kind of things. But I think there's a role for counsel there for kind of smart organizations, because those risk assessments and those penetration tests are going to provide some results and some reports. And it's probably not going to say, great, you're 100% secure and there's nothing else you need to do and there's no vulnerabilities or anything like that, right? It's going to be some kind of a report saying, hey, you're doing a lot of things right. Yep. You could have some improvements here. Here's some really critical gaps we need to improve on. And so you certainly want to go through all that. But what you see sometimes is when the IT department engages a vendor to do that, and then they get this report, they're not always remediating all of those issues for a variety of reasons, right? Because it's cost prohibitive, or the software's not supported anymore, or whatever that might be. And so sometimes you just make those decisions. But then later on, if you have a data incident, especially if it's tied to one of those issues, now you've got this nice piece of paper from a report a year earlier saying, hey, XYZ company knew that they should have updated the firewall or done whatever. They didn't. They got an incident, and that just looks terrible from like an evidence standpoint, right? So what we can do as counsel, it's not bulletproof, but what we'll do is we'll come in and kind of advise. We'll engage that forensic firm, IT security firm on behalf of the organization at our direction, as a part of a larger bit of analysis for the organization, right? So we're helping the organization analyze, all right, what is your compliance with state law or your contracts? Are you meeting those obligations under HIPAA, whatever that might be? And so then arguably those reports and those findings are privileged and help us inform that. So, you at least have some defenses to producing this terrible report in a deposition.
And that's where I wanted to go. Sorry to jump in, but I wanted to dig into that privileged aspect of it, right? Both from kind of what we do, right? Offensive security, security testing, things like that. So talk about what privilege is, Because I think, we can say privilege and us IT people are like, oh yeah, we kind of understand, but we don't understand it how you would probably describe it. So what is privilege? What is the need for it? How does it help in this scenario? And how does that help with incident response and other security assessments, like a risk assessment or a pen test even?
Yeah, that's great. Yeah, that's right. Because privilege in the IT context is often sometimes different, right? So when I say privilege, it's, it's protected from discovery, right? And so if there's ever litigation, a lawsuit over a data breach or over anything, there's a period of time called discovery where there's an exchanging of documents and there's depositions and basically gathering all the information that there's other side's going to use against you. And so privilege is a way to shield information and documents and people from that discovery process. No, it's not, it's limited, right? The courts don't want to let that be too broad, but what they want to protect is communications between attorneys and their clients, or the thought process for attorneys and the experts that they're engaging. And so, like in an incident response, we'll engage the forensic firm on behalf of the organization to help us again analyze. All right, does this organization have any data breach notification obligations? What are they? Who do we need to be notifying? And so we have that investigation is arguably privileged, meaning that if there was litigation, there is some level of protection and not having to produce all the emails and phone calls and reports and things like that. Now, there are decisions that kind of push back on some of those things because there's a distinction between a business investigation, an IT investigation, and a legal one. And so, you still want to be very careful, but there's no reason to not give yourself every tool in the toolbox to try to protect those things, because when you start an investigation, you don't know what those results are going to be until it's too late.
Sure.
So once you've started the investigation without counsel, you've kind of lost the opportunity to obtain that privilege, and so you really got to be in there and have them do that.
So it sounds like you have to set this up beforehand, right? Whether it's an incident or a security assessment or pen test. What are the kind of the requirements? You have to engage counsel first before kind of procuring the assessment, before having the assessment done, before having the breach. What does that kind of look like?
Yeah. So ideally you have outside counsel, and then they'll be the ones engaging that vendor either before an incident or after an incident on your behalf at our direction. So really, we should be the ones directing that vendor to conduct certain analysis and all right, we want you to tell us if there was exfiltration of data, right? That's an answer that experts providing to counsel for counsel to then advise the company. So really, legal counsel should kind of be in the middle and kind of be the hub and spoke for all the different service providers. And so that gives you the best argument for privilege. So then if you have those bad findings, you have arguably some protection there. And it doesn't we're not in there. We're not in there looking at the logs. We're not in there on every single technical call. So it's especially on a proactive pen test, it doesn't take a lot to have counsel overseeing it and directing it, but we can then review that report. Make sure, hey, it needs to be factual, but if this ever does get produced, is it written in? Is it objectively true, and is it written in the best way that we can? So there's other bits of advice, and
So I think.
We don't want you to get a report and then stick it in the drawer and never do anything with it either.
So I think from a setting this up before an incident, or hopefully not having one, but with this in that context, if I were to procure a penetration test or a security assessment or something like that, just as part of normal business practice, would it make sense to involve an attorney like yourself preemptively, so that any results or artifacts produced from that process are then privileged and confidential, so that 10 months down the road, should an incident or any type of discovery happen, right? It doesn't even necessarily have to be an incident. There are lots of types of legal actions that can be taken. Does that set me up for success to protect the deliverables from those processes?
Yeah, absolutely. I mean, and not every organization maybe thinks has the risk that warrants engaging counsel on something like that, but we at least want them to understand that that's an option and something they should be thinking through thoughtfully. Because once you've done it and you're in the process, you can't go back and do that. So I think there can be a ton of value, for not that much time, on the counsel side to do that. So I think it's certainly worth looking
Does that, to kind of follow on that point, does that kind of protect or limit what a firm or organization has to share from like a business obligation standpoint? Because a lot of law firms, right, we'll do a pen test and we'll give them an attestation letter or a report. that says you had a security assessment, you had a pen test on this date, it was using these industry methodologies, and it's our stamp of approval that says yes, we did this work. And then they share it with their clients who ask and say, hey, did you guys have a pen test? And they're like, yeah, we had a pen test. Here's our letter, right? But some of them, as you know, ask for the report or ask for more details, right? They want the findings or the severity, or they just in general ask for more information on their end. So does that kind of protect firms from those kind of requests as well? Or is that something that is individual to the business, to the contract and relationship?
Yeah, I mean, I suppose it would give the client another reason of why they wouldn't produce that to their customers. Like, hey, we'd love to, but gosh, the lawyers are telling us we can't, love to be a scapegoat for those kind of, preserve their business relationship.
Yep.
But really, anything you're producing to a customer in that kind of context is going to be a voluntary business deal. I mean, you don't have to produce anything to your customers if you don't want to. So whether it's privileged or whatever is kind of separate. But, if you do, you have to be careful, though, because if you have a privileged investigation, a privileged report, you do start giving that to customers. You've waived whatever privilege you have, and now it's just like you didn't have counsel in the first place. Yeah. So if you do want to have that protection, then you have to keep it confidential and keep it within a close-knit group of people that are actually directing the legal analysis.
So in that case, if you do have a pen test, right, and it is privileged, and you've got that relationship ahead of time before the engagement, you can't just share it with the expectation that it's going to stay privileged.
Yeah, that's right. Yeah.
So my background is in the financial world. So I worked for a lot of big banks and stuff like that before I came on here. And what comes to mind for me is we would routinely do application penetration tests, right? And as you guys can imagine, banking applications are a big deal. They're the primary interface for clients with regards to, financial and data and things like that. So, I would want, if I were a banking executive, I would want my legal team or outside counsel to be involved in the procurement and execution of application penetration tests. And here's why I say that is downstream 6 months later, if we haven't resolved issues and that turns into an incident as a result of those issues not being resolved, I am very exposed at that point. And it would make a lot of sense to me as a layman to say, I would love to have Alex be on that, and have that, all of the artifacts from that. Now, my biggest question would be, is my assumption correct in that it would protect me if from litigation that stems from an incident that, that kind of ties back to a test that identified those issues?
Mm-hmm. Yeah, absolutely. I mean, I think it's, especially in a highly regulated industry like financial services or healthcare, I think it's well worth the time and investment to bring in counsel early on those kind of things. And really, I think there's a lot of good advice we can be providing. And okay, what should we do based on the penetration test? What are the real risks of it? Because it's not self-explanatory, to everybody. And so I think there can be some guidance there as well, in addition to just kind of that privilege protection. So I think you've got a great argument that it would be privileged. Now, I'm not going to say it's bulletproof, right? I mean, the courts, there's state courts and federal courts, and judges have different opinions on what's a legal function versus a business function. So, you can find cases where a judge is going to scrutinize some of these relationships and say, all right, what did the engagement letter say? And what was the purpose? And did you follow all the rules? But do you want to just go, this seems hard, let's just not give ourselves any arguments at all? I don't think so. I'd much rather have all those arguments and, is it actually going to go to litigation? And so I think it's well worth having all of those put together. And like I said, even if, when I'm reviewing a report, whether it's a forensic report or whatever it is, I'm reviewing it with an eye that, even if this should be privileged, it might still get produced, right? An executive may go, you know what, I want to give this to a regulator or auditor or whoever, so we are still very careful in what we're doing, but you just want to preserve all those arguments as much as you can.
Yeah, that was actually going to be my next question with regards to precedent and case law. And it sounds like it varies is the answer.
Yeah, it does. And, you might have a very large breach where it makes sense to have one forensic investigation be through the business department that'll be produced, and one will be strictly through legal, and you have all these different tracks. I mean, depending on what you're dealing with, you can really, not go overboard, but you can really dig into it. But I'll say for the vast majority of these incidents, it's worth going through all these steps. And most of them aren't going to lead to litigation with discovery and that, but you never know. And so, it's worth having that. But yeah, I mean, the case law is going to differ on, there aren't that many areas where, no matter what it is, where everyone's 100% consistent. And so it's kind of, all right, hedging your bets as much as you possibly can, within reason.
Awesome.
How do those investigations impact organizations, right? Let's say there is litigation or there is a situation where you need to provide information about an incident or some sort of security event or data breach or what have you. What's the impact look like? What's kind of that process look like with counsel, obviously, and kind of how that kind of plays out, how you guys can provide value in that kind of situation?
Yeah. So a lot of it's going to depend on the industry, the type of incident. So, you have a data incident, you do an investigation, it turns out there was access to, social security numbers for 100,000 customers or employees, whatever. Like that, going to use as a hypothetical here. So you're going to be notifying those individuals. You're going to be notifying regulators in certain states. If you're a healthcare provider, you're probably notifying Health and Human Services. If you're a financial institution, you're notifying your regulator. And then any one of those regulators could initiate an investigation because they just want more information, or they think that, hey, why didn't you take more steps to prevent this? Or, gosh, you discovered this a year ago. Why did it take you so long to notify individuals? There's all sorts of things that they can dig into. And state attorneys general like to use these sometimes to show, hey, we're being tough on big business or tech or whatever that might be. The federal agencies have kind of different roles and reasons for investigating it. So it kind of just depends. But the most of these incidents, there's not going to be an investigation. Well, depends on the state. That there can be. Where we see a lot of action is obviously more on healthcare side, right? So the Department of Health and Human Services, if you're notifying at least 500 patients of a breach, you will get an investigation from HHS OCR every single time. That's just what they do. And so you just know you're going to get an investigation, and that's going to look at two things. Number one, how did you respond to the incident? But now we're going to open the hood and look at your entire HIPAA compliance program. How did you get here? What's your risk assessments? Let's see your policies and procedures. And so you may have an incident, even say at a vendor, right? You have a healthcare provider and they have a vendor that has an incident. You didn't even have a breach of your own systems. You may still have to go through a whole investigation and all that underlying, compliance work, which can be a lot, especially for a small organization or a larger organization. It's even more because there's so much paperwork out of, what seemed like a small incident. So it can be quite a bit.
Yeah, and one thing I love about law firms and attorneys in general is you guys are very up to date on regulatory requirements and the changes in them. I wanted to mention the Technology Transactions Data Privacy Report because I was doing some background research, right? And I saw that you had authored a piece in that, and it spoke to the FTC implementing a data breach notification for non-banking financial institutions, right? So that's interesting to me because institutions that wouldn't normally have to report an incident at least to the FTC or to other organizations now have this requirement or are going to have this requirement. It just speaks to kind of the need to have someone in kind of your corner looking after you and kind of helping with regulatory requirements or just staying up to date on a lot of that stuff. Because it can be a lot, especially, depending on the industry that you're in.
Yeah, absolutely. I mean, as every year, different states update it, and we're kind of, there's little holes and pockets, and they kind of keep getting plugged up. And what you don't want is an organization that doesn't realize they're a financial institution because they deal with insurance or they deal with they issue their own credit card or whatever it might be. And so now they have to notify the FTC of this incident. Now the FTC, has the potential to look back and go, all right, did you know you have to comply with the safeguards rule, and let's see your information security program and all these things. And so you want to be ahead. You want to know what those obligations are before you go and tell the regulator you had an incident, and you want to get your ducks in a row. And so we can help with that kind of stuff too.
Yeah, exactly. So it seems like I'm kind of jumping around a lot, but I'm trying to find a common theme throughout this conversation. And something you mentioned sparked a question in me, which was cyber insurance. I'm curious how counsel can help with cyber insurance, like with that process, because cyber insurance obviously is extremely volatile. It's constantly changing. It's still kind of like being innovated on. And there's still, I think, a lot of misconceptions and issues with cyber insurance. There's, a lot of organizations get cyber insurance and they think they're covered and they're actually not. And there's all these clauses, right? So is there an area where counsel can help kind of either understand the language, right? Because it's also very language heavy, but how can kind of counsel help guide with that or advise when it comes to cyber insurance?
Yeah, so I think experienced counsel can help. Number one, just answer the question of why do I even need cyber insurance? I think every single organization where you've got sensitive data, or at least data that's important to the organization, needs cyber insurance. It's just unfortunately the threats everywhere, and so it's no longer that only financial institutions need it or only healthcare providers. I mean, if you have employee data, or if you have anything that would prevent you from running your business if you didn't have access to it, it's worth looking at that and investigate it. So, and there's a ton of great cyber insurance brokers that can really advise on the different carriers and the policy language, and so they're great resources for that. Where we typically come in through cyber insurance is that we usually get brought in by the cyber insurance carrier to help their insureds when they have a breach. So you have an organization that has cyber insurance. They don't really know who they should be calling for counsel or for forensics or ransom negotiations or whatever, but they have cyber insurance. And so they have an incident, they call their broker or they call their carrier. The carrier then puts everything into motion for them and says, great, here, we recommend you use Polsinelli, we recommend you use this forensic firm. We can then come in and kind of help them with all the stuff they need to do. And a lot of that is going to be paid by their cyber insurance carrier. So we're a approved panel for a lot of them, because they like dealing with firms that know what they're doing. And so they recommend us, and we get brought in right away through that. And a lot of those fees are paid through the cyber insurance, and they're not in the middle of a ransomware attack and they're like Googling like ransomware law, attorney. Like you don't want to be doing that, right? So obviously we're happy to have introductions to everyone before an incident, but going through your insurance carrier is a great way to have that put together.
So I'll throw you a curveball that wasn't in the notes. But I think it'll be an interesting question, and it's not meant to ostracize anyone. I just want to help everybody kind of put a frame of reference around, who to kind of call on, or at what point does it make sense? And that question is, what are some things to avoid, or what are some red flags when you're looking at counsel or somebody to help you in this arena, right? Obviously, you guys do a great job. What are some of the things that you think are kind of red flags, or things to kind of avoid, or things that could help you identify somebody who's not really going to be the best suited to help your organization in that situation, right? Because we talked about kind of good stuff. What are some things to kind of avoid in that, if that makes sense?
Yeah, I mean, in terms of like looking for counsel to help you on something like that, right? I mean, I think most companies have good general counsel or internal counsel or outside counsel that can help, with kind of general corporate issues or employment issues or whatever that might be. And if you ask them, they'll say, "Oh, of course we can help you with that." There's probably there's only a handful of firms that really get to do it at the kind of volume that we do, where you really do have a pulse on kind of all the changes going on. And so I'm never out there to replace their general counsel or their outside counsel for whatever. We're there to help them and everybody else. And so you can certainly ask your general counsel, but I would take a chance to kind of look outside of that and just make sure you're getting the right one. So like I'm here in Kansas City. Very few of my clients are here in Kansas City. I've got clients all across the country because it's kind of a national practice, because you got people in every state and things like that. And so, I don't think you have to look at where you're physically located. I would focus on looking for a firm that, actually has a demonstrated experience in it. There are some firms that, the entire firm is just cybersecurity. We're more of a larger general practice law firm that has a large, cybersecurity group within the firm. And so I think that adds a lot of value, where we have a large healthcare department and litigation and all these things. And so I have resources for all those things, but there's 20 of us that all we're doing all day long is also data breach response. And that's just, you're not finding a ton of firms that are doing that. And so, I think it's worth doing that due diligence ahead of time, ideally, although it's not always possible.
Yeah. I do want to get to ransomware a little bit more, and I have a question on that. But I wanted to pivot a little bit to licensing agreements, third parties, because that's another area I think counsel can provide a lot of value. Is you're either getting a new third party service, like you're buying a product or a service or something like that, or you're renegotiating terms, or you got to re-up your contract or whatever. What are some things that you see that are like common misconceptions or common gotchas or issues that you see when negotiating licensing agreements or privacy policies or MSAs or whatever the case may be with third parties?
Yeah. So I think the question is, does this vendor have access to any of your sensitive information, whether it's employee information or customer information or whatever that might be? And if so, you need to be vetting them, in kind of a due diligence process, right? So from a privacy standpoint, especially if they have access to sensitive information, okay, you need to have in your contract, either in the main contract or in an addendum, you need to figure out, okay, how are they protecting it? How are they using it? Are they disclosing it or selling it to anyone else? Because if they are, you may be, violating your own obligations under your other contracts and things like that. So from a privacy standpoint, you just need to be very clear in terms of, all right, do you have access to it? And if so, how are you using it and who are you giving it to? That's just a basic level, right? And then from a security standpoint, okay, if you have access to our sensitive information, how are you protecting it? How long are you retaining it? And they may say, oh, well, we'll retain it for at least 2 years. Does that mean you're deleting it after 2 years? Or does that mean 10 years from now, you're like, well, it's been longer than 2 years and we still have it? Because my clients hate sending data breach letters to someone that worked somewhere 20 years ago. And they're like, why the heck do you still have my information? I don't know. Our vendor never deleted it, And so thinking about security and retention. And then from a legal standpoint, it's really about kind of data breach response and damages and things like that. So, hey, if you have an incident, you need to let us know ASAP, right? You can't sit around for 30 days and kind of figure it out and then tell us when our employees had their information on the dark web and nobody told us, And so it's prompt notice. But then I think the kind of gotcha is that, maybe you can kind of work in a provision saying, all right, if the vendor has a data breach, you're going to indemnify us. You're going to pay for the damages. You're going to pay for the letters and the credit monitoring and that kind of stuff, or whatever that might be. But a lot of these vendors have very, very low caps on how much they're going to pay. All right, if we owe you anything, at most we'll pay you, 1 month of fees, and you're like, oh, that is not helping me at all, And so it's getting those what can be very large costs outside of a generally applicable cap that may otherwise apply to like a business breach or things like that. So getting that language and then getting outside of all that are some of the things that our tech trans team looks at when they're negotiating those.
Have you found those to be enforceable and actually prove to be fruitful downstream? Because I would that would be my biggest concern is even if we put it in the contract, depending on what's going on at that third party, is it going to be 3 years of litigation later and the cost of the litigation is more than what the settlement would have been to begin with? I mean, so are you finding that putting those I guess the reimbursements or the costs and stuff like that, is that actually working?
Yeah, I mean the needing a prompt notice of a data breach. I mean, once everyone kind of knows what's going on, it doesn't make a whole lot of sense to spend a lot of time saying, hey, you should have notified us in 2 days and it took 6 days. Like, all right, they should have, but that's kind of just to set expectations, I think, a lot. Although there can be cases where that makes sense to litigate. But I think having those clauses in there can make a lot of sense, because if you've got a vendor who's not stepping up to the plate and they're not doing the investigation, they're not notifying, and you have a regulatory investigation, a class action. I mean, class action, I haven't talked about that, but those costs can be huge, and so you want everything you can to make sure that your vendor is going to step up to the plate, and if they've got an insurance carrier, their insurance carrier stepping up to the plate, and so we have a lot of clients where they get to the end of it and go, all right, we want to recover from the vendor now. It's like, all right, somebody the contract. And I'm like, not good news.
Right.
Because in bold letters, we're not responsible for any data breach costs, or it's a very low cap, and that's really hard to get out of. The other thing to think about is that sometimes you'll have like a 3-year contract with the vendor. They got a data breach in year 1, and the client's like, hey, I got to terminate this. I can't trust them anymore. Well, do you have the right, if they have a data breach, to get out of it? Maybe. Is that a material breach? I mean, you kind of get in all these things. So kind of work in some of those scenarios in there ahead of time is worth some time to think about.
Have you seen cases where a client has litigated because of a vulnerability that wasn't disclosed? These big 0 days, right? There's vulnerabilities that come out, and vendors aren't always the most forthcoming with that information, right? They don't want to tip their hand to attackers and adversaries, but obviously they want to fix things as quick as they can and save kind of like a PR disaster. Have you ever seen a situation or had to kind of help with a situation where there was a vulnerability, it affected a certain thing, it wasn't necessarily disclosed in a certain amount of time, and then there was litigation because of that, and maybe there was impact, maybe there wasn't?
Yeah, those don't come up as often. Those are harder things to really pin down and say, all right, this was the cause of it, and here's the things you should have done. And so
Yep.
those I haven't personally litigated those issues, but the right case could come along where
Yep.
what you don't want to get hung up on is a clause that they would have changed if you had asked them to when you negotiated it.
Right.
Oh, yeah.
Like that. So,
Yep. So ransomware. I do want to touch a little bit more on the ransomware aspects of it. First, let's just go like right for the throat on this one. Like, should you pay the ransom? Should you not? Let's get a little bit of a take here on your perspective, Alex.
Yeah. Well, not if you don't have to, right? I mean, nobody wants to pay a ransom at all, right? So, I certainly have clients that pay the ransom, and it's typically a last resort. I mean, no one's going, I think we're fine, but let's pay the ransom just to be safe. You're paying the ransom because you have no backups. Your backups are completely gone. They deleted the backups, they're encrypted, whatever that might be. You're on, your other servers are all gone. It's all right. Do we want to start over, or are we going to pay the ransom? And even then, that's not an easy decision, right? Because maybe you've got paper, or you could look at it, or maybe you've got emails, you could piece things together. And it's like, how long is it going to take us to do that to recover
Yep.
from that? So, when we have clients that are paying, it's typically just absolutely last resort. And
Yep.
and I have healthcare providers that have ransomware and they can't treat patients. Sure. Okay, I think sometimes it makes sense to pay that ransom to get that back, especially if there's no other options. So you can have situations where it makes sense. Obviously, we look at every possible way to not have to do that, but ultimately it's a business decision, and
Yep.
I'm going to let the organization make that, and we're just going to try to guide them so they can be informed on it.
Do you think the legislation that or the potential legislation of banning ransomware payments, do you think that would be a net positive, net negative? Do you think that it kind of sounds like you would agree that it would kind of hurt some organizations that have no recourse otherwise? Even if they do get ransomed again, at least they get back up and operational for the time being. They can treat their patients. So I know it's a very controversial thing, like banning ransomware payments, but I'm curious if you think it would be net positive or actually worse.
Yeah, I think it would take a long time for that to turn into a net positive. Like there'd have to be, everybody would be doing that, and everyone's then, as a result, taking it very seriously and doing everything in place. But I mean, these companies, these organizations, these providers are already in such a difficult spot, and to say like, hey, we can't, you can't pay the ransom, or if you're going to pay it, you have to do it on your own, underneath the table, and we can't help you, and it gets real shady. I mean, they're still going to have to find a way to operate, and then it's all right. They're losing legal counsel guidance, and it's just, it's tough. I mean, so I think right now those are kind of hurting. Obviously, I'd love for ransomware to go away and we could find a way out of all that. What I don't want to do is punish those organizations more than we have to get there. And so I don't think that's the right task right now, but hey, we're always open to ideas to try to ferret that out. But I think that's putting them in a pretty bad spot that I wouldn't promote.
Yep, for sure.
So question on, ransomware, but really more broad when it comes to, criminal activity and stuff like that. Do you find that a lot of your clients are seeking out support from law enforcement? Is that a common thing? I know we struggled with that in the financial industry, right? Is because the more people that know the details of what's going on, the more likely those details are to be made public or be leaked accidentally or intentionally. And then, you can pretty much guarantee at that point, whoever your regulator is going to get involved, more deeply and quickly. So there are clearly some downsides potentially, but are you finding that there's value in involving law enforcement during this process? Or is that just, what are your thoughts?
Yeah, generally we do encourage our clients to be working with law enforcement. We want to do it thoughtfully in the right way. So I want to be involved in that notice. I want to prepare that notice to law enforcement. I don't want, some guy that's, in the IT department that has a friend at the FBI to give him a call hour one and say, hey, we've had this breach and all the stuff's out there. Like, all right, that, don't, don't do that, but I think there's value to doing that. I'll say very rarely are we getting information from law enforcement that we don't generally already know? Every once in a while, maybe they'll have a decryption key from something that, is an old variant that they you never know what you might get from them. But I think you should expect that it's going to be more of a one-way street. Hey, we're aiding this overall investigation. A year from now, maybe they can take down this organization, and that's good for everybody. Maybe they can see some Bitcoin later on. Maybe but you're not banking on it. More so, I think the benefit of notifying law enforcement is just kind of a more narrative one, just kind of selfishly for my clients. So if we're notifying individuals or regulators, they're going to want to know, did you notify law enforcement? And yeah, we did. We notified FBI and we cooperated with the investigation, not because we think it's going to directly benefit us, but because, overall good. And you never know. And, we're kind of aiding that. So I don't think there's a ton of downside other than taking up some time and making sure you do it correctly. But I think most of the time it does make sense to bring in law enforcement, but understanding that they're not going to bail you out, right? They're not going to do forensics. They're not going to get you the key. But I'm surprised sometimes that there is some helpful use there, and I recommend it.
That's awesome.
Yeah, from time to time we'll have members of law enforcement, FBI or whatever, in on some of our tabletop exercises, and I think that's a good opportunity to kind of get some of those people involved early on in the process, meet those people, just at least exchange contact information. And a lot of times, I think it was, Brad, was it Evolve or
it was
LegalSec last year, where you had somebody on the panel from the FBI, and it was a very insightful conversation. And I think it kind of goes along the lines of counsel. It's like you want to talk to these people and have relationships before you need them. Right. And I think the same can probably be said for counsel. It's like with law enforcement, have those relationships beforehand, meet those folks, figure out how they can help or how you can best support them and how you can kind of, support the investigation together. That'd be kind of your thoughts too, is like, how can you kind of, start those relationships early, and how important is that to kind of have some of that planning?
Yeah. I think having somebody in your local field office can be helpful. And as you were talking, it made me think there's one situation where law enforcement can be very helpful, and that's when you've got a wire fraud situation. So you got an email account compromise. They trick a customer into paying a fake a fake account. Hey, we changed our bank account. Please change it. It was the bad guy making those instructions, and you've got $500,000 who got wired to the threat actor. Notifying the bank and starting that process is, you got to do that first, but then, notifying FBI or Secret Service, they can really help kind of smooth things out and get that moving quickly, especially if it's a large dollar amount. And so they are very helpful in that. And so, they'll file the IC3, which is, often will get you where you need to go, but, having a backup contact at Secret Service or FBI can be helpful in those, because you only have so much time, right? When that money gets moved around so fast and quickly that you need to be working on that. And so law enforcement can be really helpful in most cases.
Is there a time frame where it's like, after this time frame, like the percentage goes statistically down like exponentially with recovering?
Yeah, there probably is. Although I am surprised. I mean, sometimes we don't learn about it for 30 days, because what'll happen is a customer will pay the bad guy, and then like 30 days later, the company's like, hey, you're overdue. Like they don't send a reminder until like a month later. And so we have had cases where it's taken a long time and they still do recover some, but I think absolutely it is a function of how quickly and how sophisticated the threat actor is. So I would never say, hey, it's too late, don't even try. But yeah, the quicker you can get on that, absolutely.
Yeah, and I think there's this perception by victims of cybercrime that notifying law enforcement is going to somehow, because they think they've done something wrong, and they think there's going to be this punitive reaction from law enforcement, and that's just not the case, right? And so I think that people need to understand that, and like you said, it may not always benefit you directly, but there's a good possibility that it will benefit you or others downstream. They do have a lot of cool capabilities, and so I think that the guy last year at Evolve said they were recovering something like 15 to 25% of all the cases that were brought to them with those kind of wire transfers. They were recovering a reasonable number of those. And so, the tools that they have at their disposal would, especially in a BEC, man, that is, like you said, they're my third call after counsel in the bank.
Yeah.
So
cool.
Absolutely.
What else? So we talked about ransomware. We talked about cyber insurance. We talked about the need for privilege. We didn't really talk about like what is the most common thing that you kind of deal with on a day-to-day basis. Like, is there an overwhelming trend right now of BC, or is it ransomware or that? So I'd be curious on like where you spend a lot of time, like what kind of, what area?
Yeah, it's usually neck and neck. Ransomware and BEC. I mean, email compromise. I mean, they kind of flip-flop back and forth, but those are consistently over the last few years been 1 and 2. after that, right now there's a ton of vendor incidents going on, right? And those could be any kind of an incident, but it's something happening at a service provider of the company that they really can't control. They get they can't access the service, or they get a letter in the mail, whatever that might be. Those vendor incidents are just very common and very frustrating, right? The company's like, hey, this wasn't even our incident, and yet we're the ones having to notify with all this information out there, and that's a tough one. And so that's very prevalent because there's only so many service providers out there that provide whatever, name the service. And so they're going to impact tons and tons of organizations just from one compromise at one of those companies. And so that's really popular, but we still have inadvertent disclosures, accidentally emailing a ton of sensitive information to the wrong person or things like that. And the steps you can take very quickly to try to prevent that from turning into a disaster, and ATM skimmers. And, we do have, for financial institutions, you do have online banking compromises and vulnerabilities and, all those kind of things. So ransomware and email compromise certainly take up the most time. I think just the last thing on my mind, again, try to think about what's helpful to the IT audience to make my life easier as counsel is, preserving evidence is honestly like the biggest piece of it. You've got a disruptive incident, you've got encryption or whatever that might be. Hey, good news. We have backups from 24 hours ago or a week ago, whatever it is. We're gonna wipe that, restore from backups, and I think we're gonna be good here. And I get the need to be back up and running as quickly as possible operationally, but you start wiping forensic evidence, and there are just so many bad things that can happen. I've had, more clients than I'd like to say that had ransomware or something like that. They did have backups, which is great. They just called their IT provider, who then, wiped it, restored from backups, and didn't do anything at all. Kind of moved on and said, "Hey, good news, we're back up and running." And then 6 months later, their data's in the dark web. All of their customers are contacting them and say, "Hey, did you have a data breach?" And they go, "I don't think so." Wait, I guess we had this thing from a while back. And they're like totally on their heels. They've lost their credibility. I mean, just really bad. And again, the IT provider was on top of it, kind of, but then went too far. And now they're in like a really difficult litigation and regulatory investigation and all of these things because they didn't preserve it. They didn't think about what's the bigger picture here, and it caused a lot of problems. So just kind of thinking about those things, I think will add a lot of kind of IT professionals to add a lot of value and say, hey, here's what we're going to do here. But have you thought about talking to counsel? Have you thought about talking to forensics and your insurance carrier? If you want us to just wipe it, we can. But like, hey, let's be thoughtful here, and it's worth some time to do that, so you're not, making some really bad assumptions later because you have no idea what was taken. You have to just repeat everything, which is not good.
Yeah,
I mean, just from my perspective, if I'm sitting in an executive seat somewhere, my first call at the first sniff of an incident is going to be to involve counsel, because I need everything from that point forward to be protected. Right. And all of the actions that we take, you guys are going to know better than I am, what's going to get me in trouble downstream. Right. If this ever does go to litigation, if there are long-term, legal and financial impacts to that, I want to protect as much as I can, both with the privilege stuff that we talked earlier, but more importantly, making sure we do the things right from a purely legal perspective so that we don't get ourselves, like you said, into trouble. And just having somebody over your shoulder saying, hey, that's the right thing to do, is always the right answer.
One last question on that topic, because it just came to mind, is is there like a demarcation point of when should you make that call, right? At like what point? Is it when somebody logs in like to an account? Is it when they get like a prompt notification that they didn't, that they didn't log into? What point is that point where you should call?
Yeah, calling counsel or something like that. Yeah, I mean, obviously you can't call counsel for everything you're investigating, right? But I think once you've confirmed, hey, there's something unauthorized, something actually suspicious here. This isn't just one of the many pings we're getting. All right, let's talk about it and just make sure we're not missing something here. So there's some judgment there. I'm always happy I'd rather have an earlier conversation and go, hey, keep me posted, or hey, I don't see anything here, we're good, versus, oh, this happened how long ago? Oh, okay, let's see what you've done so far. So, good. Some organizations have lots and lots of incidents all the time, and they get very good at that. Some just never have any, and so maybe they're not sure and they call right away, which is great. I'd rather they did that than sat on it for too long. But there's some judgment there, and sooner rather than later. You can't put it back in the bag once you wait too long.
Yep.
Good stuff, man. Well, listen, Alex, thank you so much for being on. This has been really insightful. I learned a lot, and hopefully our listeners are really going to enjoy this and take a lot away from it. So, folks, that's all we have time for today. I hope you have a good afternoon. If you like what we're doing here, please like, subscribe, and the best thing you can do for us is to share this with your peers and let people know what we're doing. And we'll see you guys next Wednesday.